Yes.
That's 9. Good evening all. Any doubts in article 14 and 15? Or shall we start 16 then? Did you put the heading article 16? Equality of opportunity in public employment. Fine? Yeah. So let's write down the points and then we'll start discussion. 16 clause 1. 16 clause 1. State shall ensure state shall ensure equality of opportunity in public employment, or no Indian citizen shall be denied also you can write. State shall ensure equality of opportunity in public employment. Equality of opportunity in public employment. That is clause 1. Clause 2. No citizen shall be, remember obviously 15, 16, 19, 29, 30 only for citizens. No citizen shall be denied, or no citizen shall be, we can say no citizen shall be denied opportunity in public employment no citizen shall be denied equality in public employment or equality of opportunity in public employment. Equality of opportunity in public employment on the grounds only of. Denied the equality of opportunity in public employment on the grounds only of, same, just write that, religion, race, caste, sex. No citizen shall be denied equality of opportunity in public employment on the grounds only of religion, race, caste, sex, place of birth. Religion, race, caste, sex and place of birth. These are broader ones. Fine, of course it's not so easy. Below that, 16 clause 3. These are all kind of exceptions. 16 clause 3. Parliament can make a law. 16 clause 3. Parliament can make a law. Parliament, this only Parliament, not state legislature, can make a law and mention and provide. Parliament can make a law and provide residence as a criteria. Can make a law and provide residence as a criteria for public employment. Residence. So Parliament and residence is the keywords. Parliament can pass a law and provide residence as a criteria for public employment. Fine. For example, under that, what they have passed. For instance, for example, Parliament has passed public employment. Parliament has passed public employment. Public employment, in bracket you write requirement as to residence. Parliament has passed public employment. Requirement as to Residence Act 1957. So underline the act. Public Employment Requirement as to Residence Act 1957. Public Employment Requirement as to Residence Act 1957. Then 16 clause 4. This is the reservation provision. 16 clause 4. State can provide reservation for those sections of society. State can provide reservations for those sections of society or for backward sections of any word. I mean, this is not the exact copy paste words, overall paraphrasing. State can provide reservation for those sections of society which are not or who are not adequately represented in the public employment or government services. Who are not adequately represented. Who are not adequately represented in the government services, public employment. Not adequately represented in the government services. Public employment, any word, that means government jobs. This is the base for reservation, 16 clause 4. Then we will discuss that. Let us write the border points. 16 clause 5. 16 clause 5. State can provide that. State can provide that. State can provide that the positions in. State can provide that the positions in religious denominations, means take it as temples, madrasas, churches, that the positions in the religious denominations or its governing board, religious denominations or its governing board can belong to particular sections. Positions in the religious denominations and its or its governing board can belong to particular sections, a particular section of society. Can belong to particular sections. Fine, we will discuss that. This is 16 clause 5. 16 clause 6, the recent one. So obviously what is it? Yeah, state can reserve up to 10% of the jobs. State can reserve up to 10% of the jobs. For obviously whom? For EWS. State can reserve, a state shall also can, a state shall reserve up to 10% of the jobs for EWS. Fine, of course, these are all public employment only, no doubt about it. Fine, again if you want to again add it, because by now you will be knowing, added by which one? Which amendment? 103rd, added by 103rd Constitutional Amendment 2019, upheld by Janhit Abhiyan case. Added by 103rd Constitutional Amendment 2019, upheld by Supreme Court in Janhit Abhiyan case. Yesterday also we have discussed that. Upheld by Supreme Court in Janhit Abhiyan case 2022. Fine. Yeah, so these are broadly the provisions. So hence obviously what is the core of Article 16 then? It is about basically ensuring not exactly reservation, it can say equality of opportunity in the public employment. One of the provision is for reservation. Fine. The first provision, first clause and second clause, what does it broadly say? The state shall not discriminate on the grounds of religion or race or caste or sex or place of birth. You should provide opportunities for all, because you might have seen during the King times and all those things, or when British was there, remember when Lord Cornwallis divided services into two actually. Lord Cornwallis, when he conceptualized the civil services, he had divided into two. These are all just for you to understand broadly how discriminations may happen. Called as So this is how Lord Cornwallis subdivided it. Covenanted services and non-covenanted services. It is known. Covenanted services and non-covenanted services. Covenanted means superior. It was only for Europeans. So whatever the exams that you are trying for now, All India services, central services, they are all what? Covenanted. This is inferior, means Group C, Group D, state level services, those ones. Obviously, this was for whom? Indians. Now, this is not obviously kind of course, then after 1853 Act, they allowed it, they made it open competition, was a different. But when Lord Cornwallis conceptualized it, this was how it is. This kind of a classification is not allowed. You have to open it for all, equality of opportunity in public employment. That is the core idea of ensuring that. Fine, no discrimination on any grounds. But of course, it's not so easy because you're talking about government jobs, and for a long time, even today, obviously, it's a huge political issue. Hence, remember in a lot of states, even yesterday I told you, forget about the private sector, that is completely different. I've already told you, for example, when they say that Haryana government wants to reserve 70 or 75% for locals, or Madhya Pradesh wants to do it, or Andhra Pradesh wants to do it, or Karnataka wants to do it, Constitution and as well as Supreme Court, as of now, they have not endorsed or they have not supported reservation in private sector. You can't impose it. If they want to, they can do it, that's left to them, voluntary. But no reservations in private sector for anybody. That concept is kept out, you forget about that. Fine sir, but my government is telling like this, that doesn't matter at all. They do it for political electoral reasons. Till now, legally it is not allowed. Clear? So reservation in private sector, keep it aside. You're talking about which one? Reservations or whatever it is issues in the public employment. Now look at 16 clause 3. One of the times what they tell is, for example, they'll tell that only locals, even in government jobs I'm telling, only locals will be allowed. For example, that's why what they do, if you look at 16 clause 3, they tell Parliament shall pass a law and provide residence as a criteria. Residence means what? That you should be a local kind of a one. Sir, then but my state legislature passed it. You might see that, for example, in state legislatures also they do it. How they do it? Because the constitution doesn't allow them, they do use indirect way. I have told you multiple times what they tell. That in your 10th, the local level, let's say for example, if you are applying in for state government jobs in Maharashtra, they'll tell in your 10th certificate, Marathi should be one of the language. If you have studied in, let's say Tamil Nadu, how will Marathi be one of your language? Let's say you have studied in Odisha, how will Marathi be one of your language? That is one of the ways. There are different ways. Or what they'll do, if you want to apply for state government jobs, what will they tell? You pass Marathi exam. Then how will you pass Marathi exam? Can you pass? Obviously, it's not so easy. So those are all different indirect ways of ensuring that locals get into the state government jobs. All these things also have come to Supreme Court. Most of the things Supreme Court, a lot of times have declared it unconstitutional also. Some 2-3 years back in Uttar Pradesh they had done that. I think some 30 or 40% jobs should only be given for Uttar Pradesh local women, something like that they had told. That also Supreme Court said nothing doing, remove it. But state governments, we all know that because they are also under huge pressure to favor locals in the state god jobs. That's why what they do indirect ways. Constitutionally, only Parliament can make the law and make residence as the criteria for jobs. Clear? So that is 16 clause 3. Got it? Yeah, then 16 clause, 16 clause, just clarify in margin, wherever you have written 16 clause 3, somewhere you can add that. First point, what is the clarification? Did you get that? Constitution does not support reservation in private sector. First point, you clarify that. Article 16 also you can tell, Constitution does not support or does not talk about, you can say, Constitution does not talk about, does not mention reservations in the private sector. Does not support reservations in the private sector. Fine. Even Supreme Court has not supported it. Even Supreme Court has not supported it. Even the Supreme Court has not supported it. Okay, that is one. Then two, another one you clarify. Only Parliament can mention residence as a factor, as a ground for reservation. only Parliament can provide residence as factor ground for reservation. This is 16 clause 3 explanations. Only Parliament can provide residence as a ground for reservation. Fine, then how do the states do it? States use indirect methods because they are not allowed to do it directly. State use indirect methods. State use indirect methods like what? Like language based examinations. State use indirect methods like language based examination. Fine. Language as one of the subject in 10th or 12th. State use indirect ways, indirect methods like language based qualifying exams, or what critical language as one of the subject in 10th, 12th. Fine. Education certificates to be issued by the state, what do you call as this, what do you call it? Education boards, matriculation boards like that. Education certificates to be issued by state boards. Etc. So these are all different ways. So constitutionally, what is it? Legally, they are not allowed to do this. Clarify that, always keep it in mind. Because constitution, sir, is it good or bad? That's a different issue. Constitutionally, state governments are not allowed to do this. According to the constitution, state legislature or state governments do not have such power. So that's why a lot of cases are pending in the courts. Constitutionally, state governments are not allowed to do this. Clear? That is one angle, private sector one, and how they use the residence one. And what you have mentioned, the parliament requirement as to residence, what you have mentioned, clarify that as of now it is applicable only for Andhra Pradesh, Telangana under 371D and E, where you have written Parliament Act 1957, Parliament requirement as to, Public Employment Requirement as to Residence Act. For that you clarify, as of now it is applicable. Earlier it was there in few parts of northeast also. As of now applicable only in Telangana and Andhra Pradesh, 371DE. Remember the asymmetric federalism. As of now it is only applicable in Telangana and Andhra Pradesh under 371 capital D capital E. Don't write it D then, 371D separate, 371E separate. Under 371 capital D, 371 capital E, special status. Clear? So this is 16 clause 3 clarification. Now what does 16 clause 4 say? Look at it, they have not explicitly mentioned OBC, SC, ST, minority, nothing they have mentioned. What is the point? You can provide reservation for those sections of society who are not adequately represented in the government jobs. Fine. So, sir, what do you mean by adequately represented, sir? Iska percentage kuch hota hai kya? There is nothing like that. Now, but that is the base for reservation. Obviously, lot of state governments had earlier itself provided it. Then this, if you can recall, at the national level, that means in the sense Government of India jobs, till, just to give you an idea, you can, if you want to, if you take using 16 clause 4, what state governments had done was, because remember that the 16 clause 4 says state, that is not necessarily Government of India also. Who also comes? Legislature, executive of who? State also will come into picture. So state governments, most of the state governments had already provided reservations for OBC, SC, ST in lot of states, even for women also. All those things had already done. Fine, this is but which level? State government level. But Government of India level, that is UPSC kind of a jobs, whatever you call it as, or SSC kind of a jobs, for a long time reservation was only for whom? SC and ST. It was only for those two sections. Clear? We are not talking about Lok Sabha Assembly, wo chhod do, that is different, 330, 332, that is legislature. Government jobs I am telling it is only for SC and ST. Later what happened, there was a commission called as BP Mandal, or take it as Mandal Commission, which is officially called as Second Backward Classes Commission, because the first Backward Classes Commission was headed by Kaka Kalelkar. That is in 1960. This is second backward classes commission headed by BP Mandal. Now this was appointed in 1977 by Janata Party. They gave the report, all those things. Like because the government was not in power, Janata Party, then Indra Gandhi came back to power, the report was sidelined. Later when VP Singh became Prime Minister in 1989, he said, we will implement Mandal Commission report. And VP Singh government announced that we will accept it and we will provide 27% reservations for OBC. At which level again? Government of India level. States, leave it to them, they have already done it, that's a different issue. And it keeps varying it also, that's a one. Fine, Government of India, like how the EWS happened, this one. Fine, this got questioned because now, I mean, this was obviously the base is all Delhi. So protests had happened in such a way in 1990, 1991, remember, because pre-1991, government jobs was the only major source of job. Because India was not a social, that is, it was not what market-oriented economy, socialist economy. That means major jobs, where do you get? PSUs. PSU means you understand, right? BHEL, BL, or you have to go to UPSC, that kind of a job itself. Where do you apply for jobs then? You don't have private companies. Where should the youth go? There were a lot of protests even wherein, like in front of JNU, DU and whatever, you have so many things. There even self-immolation protests had happened. Self-immolation means you understand, right? Put petrols or kerosene on yourself, that kind of protest had happened. Now it's a different issue because 30 years has already passed. EWS ke liye itna protest nahi tha because a lot of private sector has expanded. Hence, it became a huge controversial issue. Hence what happened, PV Narasimha Rao, who became PM later, he added a provision and said, okay fine, we will also give 10% reservation for the top caste under a provision called as what? EWS. So what you have brought EWS now, it's not a new provision. PV Narasimha Rao government in 1991 itself had told, because the upper caste had protested, as I said now, self-immolation, to convince them, they said, we will give you 10% reservation also, don't worry. This is for whom? Non-OBC, whatever you have now, exactly copy-paste. That one was this. Everything got summed up into the landmark case called as Indra Sawhney case in 1992. Fine. So 1989 VP Singh, 1981 Narasimha Rao, all combinedly went here. And it is famously called as Mandal case, OBC case, so many things they call it as, but official Indra Sawhney versus Union of India. And what all did Supreme Court say? First point, it upheld the reservation for OBCs in government jobs, 27% upheld. 2, they said EWS reservation is not allowed because reservation is only for socially, educationally backward class, it is not for economical sections. Cancel. 3, they told, whatever it is, total reservation should not cross what? That you know, 50% it should not cross. Extra, except in extraordinary circumstances. But what is that extraordinary circumstance? That we don't know. That depends on case by case basis. Then, no reservation in promotion. Reservation only where? Entry level, appointment level, not in promotion. Then, creamy layer. Identify within the OBC creamy layers. Creamy layer means basically what? Those who are well off. Take them out of reservations. Others, non-creamy layer only should get OBC reservation. Then they said for all this purpose, appoint a statutory body so that they can include the caste, exclude the caste, all those things, because you have to keep on identifying. Hence, National Commission for Backward Classes was made a statutory body under NCBC Act 1993. Because judgment came when? 1992. So 1993. Ramanandan Committee was appointed to identify the creamy layers. Like this, many were there. Those are all too much of details. Basically, this happened. Got it? What is the first point? OBC reservation of 27% upheld. Sir, why only 27%? Actually, they made it 50%. According to Mandal Commission, overall if you take it in India, OBCs are minimum around 55 to 60%. Fine, because OBC itself is 60% of India's population. SC is around 15-16%. ST is around 7 to 8%. Minorities are around, whatever you combine it, it will be around 15%. And the top caste is 2 or 3%. Now look at it, that's why they say, how for OBC 50-60% people you are giving 27% reservation. For 2% people, how much are you giving? 10% reservation. Those are all the criticisms. For minorities you have 15%, there is no reservation. So how are you, this is disproportionate one, it was the criticism one. That's why they removed it saying nothing doing, and plus if you don't know the idea of reservation, even this was exact statements of Ambedkar itself, even Supreme Court has told it, the idea or the purpose of reservation is not poverty eradication. Just because you make, like let's say 10 SC candidates or 20 SC candidates IAS this year, you will not eliminate the poverty of what 16% means how many crores SC are there. Let's say 20 crore SC population is there. By making 20 IAS every year, will you remove the poverty of 20 crore? It is not for that. The idea of reservation, what they have told is to provide representation for the backward sections in the public employment. Representation means what? So that if you look at government officers, there should be people who belong to top caste also, OBC also, SC also, ST also, women also, minority also. It should reflect their concern, and the overall idea is that this is the core administration. The overall assumption is, because if you come, I mean, let's say you have come from particular caste, the idea is that you know the struggles of that caste, you know what kind of discrimination they face. When you are put in public employment, you will try to, at least the assumption, sir, has it worked or not, that's different criticism part of that's the criticism part, that you will work for their welfare is the assumption, because you know that problem. Very simple logic. Let's say a female knows a man can empathize what might be the problem of females, but female, because she going through that problem, she will understand what are the real problems of women. Now if you give her the position, she will tackle those aspects better is the assumption, which is also more or less true also. We are not saying no. Same assumption is for SC reservation also, ST reservation also. They have gone through it, they know the problems better. If a higher caste tries to understand the problem of ST, you may try to understand, you may empathize, but you may not really understand it. Reason? Because you have not gone through it. That's the reason they have done all these things. We assume in general that it is for poverty eradication. Absolutely it is not for it. This is Ambedkar has told in assembly, this is Supreme Court has said in so many cases. Even the EWS Reservation Janit Abhiyan case also Supreme Court said the same. Fine, so it's absolutely the same logic. Fine, clear. So this Indra Sawhney case happened, but then it did not stop there. Then what they started to say, this Parliament amended the Constitution and added Article 16 Cap 4 capital A. I mean clause whatever it is, clause 4 for that. And they said we will also provide reservation in what? Promotion. But this will be only for, not for OBC, only for SC and ST. Which is what? Which is going against Indra Sawhney case. Because what did Indra Sawhney case tell? Reservation only in entry. This is what? Promotion. And it went back to Supreme Court, which famously they called as second Indra Sawhney case and all those things. Supreme Court said nothing doing. Cancel. Again Parliament went against it and they said no, we are going to give it. And then they added a provision called as consequential seniority also. Consequential seniority. This is for you to understand the concept. Sir, what do you mean by consequential seniority? Look at the word. You will become senior as a result of consequence. Let's say for example, let's take two candidates A and B. Fine. A belongs to general merit. B belongs to SC category or ST category, let's say. But GM has, let's say 10 years experience. Let's say SC has 5 years experience. Fine, SC or ST has 5 years experience. Now what will happen? Let us assume there is a position vacant here. Fine, one level above. Let's say this is SP, this is let's say DIG, whatever, your deputy director, joint director, whatever, assistant commissioner income tax, deputy commissioner income tax, like that, above one vacancy is there. Now, if you are giving reservation in promotion, let's say it is reserved for SC or ST, anything. If it is reserved for SC, now, even though if there is a competition between these two, because it is reserved, who will come here? B will come here. But who is more, if you look at the years of experience? A, but it doesn't matter. Clear? Let's say for example, 3 years later he also came here. Because maybe 3 years later GM positions also might be there. He came there. So that means A is also here, B is also here. But who came first here? Now let's say there is another vacancy, another 10 years later in the above. Who came to this position first? B came to the position first. Now, what you have to take is, you have to take the seniority as a result of the consequence of reservation. Means, you should not take the overall experience of E and B here. You should take, okay, you are going from, let's say, to IG from DIG position, Joint Commissioner from Deputy Commissioner position. You should not take overall experience. At the level of Deputy Commissioner, who has more experience? B, because who came first? B came first, but this is a GM seat. We are not making reservation promotion here, the above one. It is still open, but who has worked more in the one level below? B. B comes here. This is called as consequential seniority. That means a person belonging to SC or ST category will become senior as a result of, that means result in the sense as a consequence of reservation in promotion. There is a reverse of this rule that is called as catch-up rule. Look at the name itself. Catch-up means what? Who will catch up here? A will catch up. In the catch-up rule, what they said is, no, don't take this. Take what? Take overall experience. In overall experience, let's say this is open for GM. In total your career experience, who has more career experience? A should come first. But if you follow which rule? Catch-up rule. And Supreme Court in the recent judgment called as Jarnail Singh versus Lakshmi Gupta case has said, not this, this. This is Jarnail Singh versus Lakshmi Gupta case 2018 or probably 2019. Supreme Court's judgment. Hence, there is reservation in promotion for SC and ST, plus what applies is consequential seniority, not the catch-up rule. Catch-up rule is gone. Got it? So, these are various things. Then there is another one which is called as carry forward rule. This applies for actually all the ones, but more specifically SC and ST. Carry forward rule. What do you mean by carry forward? Let's say there are 100 vacancies. Fine. As we have already told, SC will get, let's say, around 16. ST will get, let's say, 8. OBC will get, but this all concept applies only for SC and ST categories. So, just for arithmetic I am telling, taking 100. Let's say out of 16, they found out only 12 candidates. Because minimum level of criteria they would have put, only 12 candidates they found out. That means how many are left out? 4 vacancies are left. They found out 6. That means 2 they could not fill for whatsoever reason. Candidate itself was not there. They could not clear whatever issues. So 4 and 2 are vacant. Now can you shift to their still OBC seats? They are still GM seats. Can you shift to them and fill? That means in this vacancy, can you fill a GM there? You can't fill a GM there. Can you fill a OBC there? You can't fill a SC also here. You can't fill a ST also here. That is only for SC, this is only for ST, that is only for OBC. You can't fill from others. But you can fill GM from others. That is how GM operates. That's the reason getting in GM is, because in GM is open for all. Reserved seats only for reserved category. Getting? So you will understand that broadly later. Okay, basic point I think you got an idea. It cannot be filled by others. It should stay there. That year, sir, not that year also. Next year, let's say next year another 100 vacancies are there. Fine, let's assume 16 are there. This, how many are there again last year? Plus 4. So total you will get 20 seats. Let's say 6 again, plus 2. This year you will have 8 seats, 20 seats for SC, 8 seats for ST. Now again, what is the calculation? Now let's say if you add these numbers, what it might cross? What does the Indra Sani case tell? You should not cross 50%. You should not count this number. You should count this number. That means to determine 50% category, 50% reservation number, do not count the vacancies which has been carried forward. Leave that out because that is not this year's seat. It was which year's seat? Previous. Leave that out. That's already reserved. This year or the next year, it's finally for that category only. You leave them out. You should calculate the 50% only using the newly called for vacancies. Do not assume or do not count the previous year vacancies. That's not allowed. That is, look at the website. You will keep on carrying. You can't fill by others. 2. In calculating 50%, do not count the carried forward seats. Those are all old ones, only use which one? New ones. Getting an idea? So this is also another one which has also been upheld by Supreme Court, carry forward rule. There is no years mentioned in the constitution. Did we mention the year there? So it's left to the governments to decide. How long? That's left to the governments to decide basically.
Sir, but for the OBC category, there is a application of the carry forward rule along with the 50% cap, right?
Yes, for OBC also it applies. But more specifically it is for, because the provisions more specifically give priority for SC and ST. Yes, for OBC also it applies. Any reserved.
With the cap of 50%?
No. Take out 50%. Any reserved category if you forward, I don't think it applies. Carry forward rule is for all. But idea is mostly about SC and ST because in state level all it varies. Because those two are the most weaker sections in the society because of the historical factors. But you apply for any reserved seat. Fine. These are all broader understanding. Nobody will ask you all these things, but you should understand the provision. This is carry forward rule. But Supreme Court said you can't do it so easily. That's why they have given a judgment called as M. Nagaraj case with respect to reservation in promotion, in which they said, okay, go ahead, but keep 3 factors in mind. What they said is, this is for reservation in promotion. Fine. First one is if you want to give reservation in promotion for anybody, community should be so this one should be the first. If you want to provide reservation in promotion, the community, that particular whatever caste you call it as, should be inadequately represented in the top level position. Top level means what? Secretaries, joint secretaries, additional secretaries, that one. 2, you should have adequate data. That means show the data, only then it is allowed. You should give so and so percentages and everything. And 3, don't compromise merit. This one Constitution also says in Article 335 that any reservation for SC or ST or anybody that talks about 335 should not compromise the merit and efficiency of the administration. So don't compromise the merit and efficiency of administration. Fine. These are told by Supreme Court in M. Nagaraj case. If you want to provide reservation in promotion, fine. But in Jarnail Singh case, Supreme Court has said there is no need of this. You just go ahead. You don't have to show the data. You don't have to also have to show this. Just keep going ahead. This is Jarnail Singh case. The recent one just now I told you, remember Lakshmi Gupta one. That's the point. Then another one comes which is called as vertical and horizontal reservation, which is recently in news because of so many issues. Vertical means what? Let's say for example, if I am giving reservation for OBC, SC, ST, EWS, this is called as vertical reservation. And when you are calculating 50%, you have to calculate only this. But there are horizontal reservations also. Let's say for example, within OBC, women, within OBC, rural, within OBC, let's say for example, physically challenged, within OBC, you may use some other things. Let's say for example, armed forces. Like ex-army when they tell, those are all horizontal. Horizontal means what? Within every reserved category you will have it. Within SC also you will have for women, rural, whatever this is, there is everything you add. That is horizontal because it is given like that. It is written like that. This is vertical means it is based on your caste. That is based on other factors. See, women is not based on your caste. Rural not based on your caste. Physically challenged not based on your caste. Armed forces not based on your caste. Fine, in every category, because you understand, right? Here also there. This is not there as of now, but state level they provide it. For example, in Karnataka within OBC there is 1A subcategorization, 2A, 2B, 3B like that. That is called as, that is another one which is the recent one. You know, at least got an idea what is vertical, what is horizontal. if you give reservation based on caste, it is vertical reservation. If you give it based on other criteria which applies in every category, it is called as horizontal reservation. X-axis, Y-axis. One second, there is another one which is called as a recent one. Government of India has set up a committee for, what is it? Because remember, as of now at the Government of India jobs, you don't subcategorize OBC. OBC means as a whole OBC, as a overall. But there is a recent commission called as Justice Rohini Commission, which has not yet given its final order, final report, but the commission has already identified that within the OBCs, almost around 30 or 35% of the castes have got no reservation at all. Reason, because within OBC there is a class within a class. Means within OBC there are a lot of castes which are very powerful. Powerful in the sense they are already well off. And the people or the aspirants who belong to that OBC will keep getting through the service. Other OBCs they don't get because they are not that level. Hence what they are telling, subcategorize. Subcategorize means what will happen then in the future. What you have the 27% reservation for OBC, so it will become like, let's say for example if they divide into forward OBC, backward OBC, least backward OBC, like that they'll subdivide. Let's say they divide it into A, B, C, D. So some 100 castes, 1000 castes they'll put it under A category, B category, C category, D category. So you will get maybe 8%, maybe 6%, maybe 6%, maybe the rest whatever percent. Now if you belong to B category of OBC, you are only eligible for how many reservations? 6%. As of now, you have access to all the 27% seats plus GM. If you go into subcategorization, you will only have access to this 6%. And plus GM. So 27% will not apply for you.
Sir, in future can it be for SC, ST also?
Subcategorization. Anything can happen, but even if you look at across the country, as of till now, I am not sure about each and every caste, there is no subcategorization within SC. Some states in the south are trying for subcategorization. Within SC subcategories. There are some SC which are again forward, some SC which are again backward, but it's not so easy. And if you don't know, as of now, there is no creamy layer within SC and ST also. Creamy layer concepts only applies for whom? OBC. So a lot of issues are still pending. There is also a demand to give reservation in private sector. Reason, government jobs are obviously has reduced a lot because today is an era called a small state era. So now look at it, if they go for lateral entry, all gone, so many jobs will come down then. And every year, every month, according to the reports, every month I am telling 10 lakh new people are entering the labor force. Not the old ones, leave out, you are all already old now into the labor market. Every month the people who follow you, 10 lakh. Means 1 year you have 1.2 to 1.5 crore new people entering labor force. Where do you find jobs for them? And we have entered the era of Industrial Revolution 4, where so many jobs are what? ChatGPTs, all automated. Government is not ready to increase the jobs. In private sector, automation. Then where do you have jobs? Self-employment, Indian mindset doesn't agree self-employment because job security. All these issues are affecting a lot and we are not worried about it because so many other issues are still pending. So we'll have to see how it goes. This is a very, very huge issue, unemployment. Now you ask the doubts.
So as you mentioned for the adequate data.
Correct. That is what is M. Nagaraj case.
Right. So adequate data means the caste census?
Yes, not exactly caste census. For example, in the Government of India jobs, let's say secretary level position, how many are there? How many belongs to what categories?
So when was the last caste census?
That was British era, 1931.
So why aren't they conducting?
Because it is a very political issue and if you identify that, you will get to know which caste is more, which caste is less, which caste is better, forward, backward, then reservations have to be redone, undone, so many issues are there. That's the reason. And if you get to know that this caste has more population, because we are all using the numbers of that era. Let's say if you get to know that actually this caste number has increased, then they'll demand more reservation. So it's not, caste is a, you know that, as very famously said, caste is in the subconscious of Indians. It's like It's like in our blood. So these are all huge issues which is related to Article 16. Reservation private sector, OBC subcategorization, Indra case, recent Janhit Abhiyan case which I have already explained yesterday, and subcategorization of OBCs, SC, ST, creamy layers, reservation in promotion, carry forward rule. All these things is the bigger picture.
Sir, EWS comes under vertical division?
Yes.
But you said it's based on caste, the vertical division.
Yes, it is also based on your caste. What else it is based on? First it is based on caste, then within that economic, EWS is for whom? GM, non-OBC, non-SC, non-ST, simple words, top caste. It is only for top caste. Under that, you should be economically poor. It is basically the same only. That doesn't mean it is for all the economically backward. Sir, I am poor. Doesn't matter. You should belong to non-OBC, non-SC, non-ST. Sir, I fall in creamy layer of OBC, can I get EWS? Not allowed. Fine, so don't, that all logics will not apply here.
So what is the criteria of subcategorization of OBCs?
That final report is not yet come. They'll do it, whatever, so many logics are there, they'll do it. For example, in Karnataka they do it as 1A, 1B, 2B, like that they do it. They'll start with the least forward OBC is 1A, a relatively better is 2A, relatively better is 2B, relatively better is 2C, relatively better is 3A. Within OBC the top is 3B. Means within OBC, because not all OBCs are same. Like you take Jats, it may be one OBC, or in Haryana it's a GM itself, let's say in UP, but the Jats means what you know, they are all very powerful, socially, politically powerful community. You can't put them under least OBC category. You should put them under top OBC category. So like that, yeah, so many are there, you know, in every state it varies. Patidars, maybe OBC, but it doesn't fall under the low, top OBC there. Reddys, you might have heard, Reddy, Marathas, they are not least OBC, they are top OBC. So like that, every state has so many things, you know that, how many castes, so many subcastes and all those things, subcastes. So it's a huge categorization.
So sir, the carry forward rule is also impacting the administration, right? The third criteria.
Administration in the sense efficiency and all those things. That's what, it's a very subjective question, it's not so easy to judge, and Supreme Court has said you have to go forward means you have to go forward. There are, in fact there are criticisms that reservation itself will affect, but it's a completely different perspective because social welfare, affirmative action idea. Fine. Yeah. A very, very broad concept this is. Yeah, please note down all these things. What did you write? Let's write this. To mention few points. In the Government of India jobs, in the Government of India jobs, in the Government of India jobs, earlier it was only reserved for SC and ST. Earlier reservations were only for SC and ST, or earlier it was reserved only for SC and ST. So then what happened? Janata Party appointed. Janata Party means take it as 1977 to 1980. Janata Party appointed Second Backward Classes Commission. Second Backward Classes Commission headed by Mandal, BP Mandal. He was from Bihar. Second Backward Classes Commission headed by Mandal. It recommended 27% reservation for OBC. This is jobs. It recommended 27% reservation for OBC in government jobs. It recommended 27% reservation for OBC in the government jobs. Fine, but when was it implemented? The report was implemented by VP Singh, 1989, 10 years later. The report was implemented by VP Singh government, Vishwanath Pratap Singh. Report was implemented by VP Singh government. This is for you to understand the chronology, that's it, or else a lot of people will have that confusion when what happened. Implemented by the VP Singh government. Fine. PV Narasimha Rao government gave 10% reservation for EWS also. PV Narasimha Rao government gave 10% reservation for EWS because there were a lot of protests against OBC reservation. Gave 10% reservation for EWS also. Fine. Now put the heading, the landmark case for reservation in Indian history. Indra Sawhney case, 1992. Indra Sawhney case, 1992, which is also called as I said, reservation case, Mandal case, anything. Fine, it's a very, very important one. Now tell, what does it tell? First point, OBC reservation, 27% reservation for OBC upheld. Keep reading in points under that first one. 27% OBC reservation upheld. 27% OBC reservation upheld. Fine. 2. Reservation for EWS not allowed. Reservation for EWS not allowed. Reservation for EWS not allowed. 3. Total reservation means what? OBC, SC, ST all combinedly we are telling. Total reservation should not cross ceiling limit. Total reservation should not cross how much? 50%, except in rare, extraordinary circumstances. Total reservation should not cross 50% except in extraordinary circumstance. The next one. Creamy layer within OBC should be excluded from reservation. Creamy layer within OBC should be excluded from reservation. Creamy layer within OBC should be excluded from reservation. Should be excluded from reservation. Fine, that is one. Then next one, reservation in promotion not allowed. Because that was also given by P.V. Narasimha Rao government. Reservation in promotion not allowed. Reservation in promotion not allowed. Then appoint a statutory, not appoint, you can say establish. Establish a statutory body. Establish a statutory body. Establish a statutory body to implement OBC reservations. Implement or identify the caste, whatever issues. Establish a statutory body to implement OBC reservation. Fine, in bracket you can write Parliament made or Parliament enacted or a Parliament passed NCBC Act in 1993, the next year itself. Parliament passed. So this is to follow the Supreme Court's order. Parliament passed which act? NCBC means you understand, National Commission for Backward Class, NCBC Act in 1993. So that time it was what kind of body then? Statutory. Later, same one, continue. These are all not told by Indra Sawhney. The body only they had told. Recently what it is made? Yeah, recently 102nd Constitutional Amendment 2018 made it constitutional body. 4-5 years back, 102nd Constitutional Amendment 2018. 102nd Constitutional Amendment 2018 made it constitutional body. So as of now it is constitutional. NCBC. NCSC is also constitutional, NCBSC ST is also constitutional. Fine, okay, that is Indra Sawhney case. Now then what happened? Article, put the heading, Article 16, Clause 4A. 16, Clause 4A. Reservation in promotion for SC and ST. Article 16, Clause 4A. Reservation in promotion for SC and ST. Fine. It was upheld by Supreme Court. It was upheld by Supreme Court in Nagaraj case. It was upheld by Supreme Court in Nagaraj case, but certain conditions were prescribed, suggested. It was upheld by Supreme Court in Nagaraj case, but with certain conditions. Upheld by Supreme Court in Nagaraj case, but copy the condition, but with certain conditions.
Adequate data to prove the first point.
Yes. And then so many other details are also there, but it's all not necessary for us. Broadly, if you understand, it's fine for polity. Because this itself, for you to remember, you have to put a lot of effort for this. First one, the community should be inadequately represented in the top level position. 2, you should have, government should provide adequate data. 3, the reservation in promotion should not compromise merit and efficiency of administration.
Which article number you mentioned?
16(4)(a), reservation in
So with regard to this third point, Article 355.
335. Article 335, it says that even the reservation in SC and ST, even though you have to provide for it, don't compromise the merit and efficiency. It is also told there. But these are all too much. Just broadly you get an idea, that's it. When that is Nagaraj case, then what happened? Write this. Government provided consequential seniority in reservation in promotion. Government provided, I can't explain this, if whatever I have told you put in your own diagrams, because for me to explain so many things you have to tell, broadly understand what you mean by that. Government provided consequential seniority in reservation in promotion. Fine, so just if you, I think you understood, got a broad idea, just put the illustration. Take it as level 1, assistant commissioner, deputy commissioner, joint commissioner. If the deputy commissioner is open for only SC, then even though he is junior, he has to go forward. Then the joint commissioner is open for all. But if you follow consequential seniority, you should take the seniority in the just below level position. Hence, if you compare A and B, B will be considered as senior, he goes up. Nobody will ask you, don't worry, nobody will ask you about all these things. If in case when you study across, you should have an idea. Fine, then write the case. I mean, if you want, you can write that rule also. Catch-up rule was in favor of non-SC and ST. Consequential seniority is in favor of SC and ST. That's it, the core point. Consequential seniority favors SC and ST. Catch-up rule favors whom? Non-SC, ST. Fine, that's the core point. You remember that, that's fine. Now you put that case, Jarnail Singh versus Lakshmi Gupta case. Just take Jarnail Singh case. Jarnail Singh case, what is Supreme Court upheld? Supreme Court upheld consequential seniority. Jarnail Singh case, Supreme Court upheld consequential seniority. Fine, and you can also sum up this in one line. Supreme Court has also upheld carry forward rule. Supreme Court has also upheld carry forward rule in which the unfilled vacancies will be carried forward to the next year. So if you don't fill that year, next year, you should just keep on forwarding. Supreme Court has upheld carry forward rule in which the unfilled vacancies will be carried forward to the next year. Carried forward to the next year, and those seats should not be used. Unfilled vacancies will be carried forward to the next year. Those seats should not be used to calculate which one? 50% ceiling limit. Those seats should not be used to calculate the 50% ceiling limit. So that is broadly the idea. Of course, some small details may vary here and there, but the broad forward, the idea is that. Fine, that is M. Nagaraj case, Jarnail Singh case. Then recent one. Horizontal reservation, vertical reservation. Just a broad idea again. Vertical reservation means what? The reservation provided based on caste criteria. That is vertical reservation. That is OBC, SC, ST as all, EWS also are vertical. Horizontal means what? Within every reserved category, other categories they will use. Vertical reservation means reservation provided based on caste parameter, caste criteria. Reservation given based on the caste criteria like OBC, SC, ST, EWS. And then what is horizontal? Reservation within every reserved category. Means within OBC, within SC as I said. Reservation within every reserved category. Based on this is what criteria? Based on other criteria like it can be for women, rural, PH, armed forces, or you can say ex-army category, they tell ex-armed forces. Got it? That is horizontal. Now EWS everything we have already done, and I have already told you that also. Yesterday itself I told, as of now EWS 10% reservation is applicable only in Government of India jobs. States, it is left to whom? States to decide. They may not. 16 class 6 or 15 class 6 doesn't enforce on them. Clear? Yeah, Janhit Abhiyan case. Then this one also you note down. This is also in news. It is not yet finalized, but it's absolutely fine. Absolutely sure you will get it. So before all this happens, get into service quickly. Because here it becomes very, very small space you will get then to get into the list. Subcategorization of OBC, Justice Rohini Commission. Fine. So these are broadly the ideas. Then 16 clause 5 is a very simple one. I have already explained that. Sir, what about minority? That will anyhow explain completely in your article 29 and 30, don't worry. Complete idea will get on horizon of this minorities. Got it? No, this is just a example to understand. This is just an example, you understand? Not the exact category. This is not being done. Then don't link that Justice Rohini Commission has said this. For you guys to understand, I gave. I think they have already given interim report. You go through it, you will understand. I can't tell you all those facts. So many facts are there. How many OBC have got the highest reservation? How many have got less reservation? So many are there. But final report is let's wait for it. Fine. Got it? That is 16. 17 is relatively simple, put the heading. Because 16 will take a lot of, then 19 will take a lot of time. Then again it will go, 25 will take a lot of time. Then 30 will take a lot of time. So it's like few articles are very, very important. Article 17, obviously what is it? Abolition of untouchability. Abolition of untouchability. Fine. Article 17 abolishes untouchability and forbids its practice in any form. That's it. Article 17 abolishes untouchability. Abolishes untouchability and forbids its practice. Forbids its practice in any form. So you can't say, sir, this way can I follow, that way, no form. Forbids its practice in all the forms, in any form. Fine. Clarify again. This 17, look at it. We have not mentioned individual, that means it's applicable for whom? All. But of course, it's a core India based because it is learned from the caste based. But still, clarify that. Article 17 is applicable against private individuals. 16 is for whom? State. These are all we have clarified. 17 is applicable against private individuals. Applicable against private individuals. But again below you clarify, Constitution only mentions the term untouchability, does not define it. Constitution only mentions the term. Constitution only mentions the term untouchability but does not define it. Mentions the term untouchability but does not define it. Clear? So, so many cases are there in which again there is a case called as Venkataramana Devuru versus State of Mysore, 1950s. Even in that case, Supreme Court again, because they are told the temples have our own way of allowing the entry and all those things. Supreme Court said nothing doing. Article 17 completely abolishes it. And we know what all various forms are there, all those things. Again clarify, Parliament can pass a law. It is not actually can, you can write shall also. Parliament shall pass a law and provide punishments for practicing untouchability. Parliament shall pass a law and provide punishments, means imprisonment, penalties, anything. Punishments for practicing untouchability. Punishments for practicing untouchability. When again look at the term, we have only used the term Parliament. That's what is our 35 also we will again write. Parliament has passed. What has Parliament done for it? Parliament has passed Untouchability Offences Act. Untouchability Offences Act. Untouchability Offences Act, which was renamed as Protection of Civil Rights Act. Parliament has passed Untouchability Offences Act, which was renamed as Protection of Civil Rights Act. Protection of Civil Rights Act. That's what I told. Civil rights, social rights means 14 to 18. Protection of Civil Rights Act. Then below that, what is the second act then? SC/ST Prevention of Atrocities Act. No, I think not prevention. I keep getting between. So just search the act. Is it prevention or prohibition? The official name is? I think it's prohibition. Just search once and write. The exact name is right, because I keep getting confused between those words. I think it is prohibition only. Just write SC/ST Act, you will get the official name. Prevention.
1989.
Prevention of
Okay, so then write the name as SC/ST Prevention of Atrocities Act 1989. SC and ST Prevention of Atrocities Act 1989. Fine. If you want, this is not a landmark, but still you can write. In margin you can write, or wherever. Venkataramana Devaru versus State of Mysore. This was 1950s, because at that time there was no state called as Karnataka. It was still called as Mysore state. Then it was renamed as Karnataka later. Venkataramana Devaru versus State of Mysore. So in this case, Supreme Court again clarified that nothing doing with untouchability, everything. Fine. Yeah, this is a very simple act against private individuals and everything. Now for the heading 18. This is also a very simple question, simple article. Article 18, Abolition of Titles. Abolition of titles. Fine, first one, it includes 4 components. 4 provisions means sub-provisions. It includes 4 provisions under that first one. It's like same 18 clause 1, 18 clause 2 like that. First one, state shall not confer. Confer means provide, CONFER. State, 18 clause 1, point 1, that's what is 4 provisions. State shall not confer any title. State shall not confer any title to either Indian citizens or foreigners. So Indian government, not just Indian government, state governments also, we can't give any title to anybody. State shall not confer any title to any individual. That means what? Citizen or foreigner. To either citizens or foreigners. Clear? That is one of the first provision. Second provision, clause 2. Indian citizen cannot receive. Indian citizen cannot receive. Indian citizen cannot receive any title. Indian citizen cannot receive any title from any foreign country, from any foreign state. Indian citizen cannot receive any title from any foreign state or foreign country. That is second provision. Third provision, clause 3. Any foreigner who is holding an office, technically office of profit and office of trust, they tell, I'll use the same word but will not discuss it now, office of profit, that I'll tell you in 105. any foreigner who is holding an office of profit or trust, that means office of trust, an office of profit or office of trust, just write office of profit or trust, under GOI, Government of India or state government, under the Government of India or state government. Fine. So, any foreigner who is holding an office of any of those things cannot receive any title, from any country, without the permission of the President of India. Cannot receive any title from any country without the permission of President of India. Without the permission of the President of India. Fine, that is clause. We will discuss that. Then clause 4. An Indian citizen or a foreigner holding office of profit. An Indian citizen or a foreigner holding an office of profit cannot receive any emolument. Remember, we already told you what do you mean by emolument. In addition to salary, some other benefits. Cannot receive any emolument. EMOLUEMENT. Cannot receive any emolument or other benefits from any country, same, without permission of President of India. From any country without the permission of President of India. Fine. So, this is what you call it as abolition of titles. In simple terms, what first point is, what does it say? Government of India, not just Government of India, take it as overall state. They should not give any titles to anybody. It can be Indians or foreigners. So, the question comes here, what do you mean by this title? Title, how they have classified it is, title is something which you are giving as a kind of hereditary concept, which you are giving just like that without considering their merit or contribution to the society. For example, British used to give titles like Raja, Maharaja, Nawab, Nizam, so many things, or Sir also sometimes. None of such things are allowed. First is no hereditary titles. 2, considering your position, that kind of a one is not allowed. But only exception is what? They can give academic and military title. For example, what do you call as this? Army General, Major, Captains, this, and doctors. Remember, if you have done MBBS or Ayurveda or PhDs or something, they will give you doctorates. That is also kind of considered as title, but they have assumed that it is considering your position or whatever all those things. Those are the only 2 titles which are exempted. Addition, you have awards, Padma Shri, Padma Bhushan, Vibhushan, Bharat Ratna, Arjuna Award, this, that, everything. That is called as award. And by definition, what Supreme Court has said is, award is something which is given considering your merit, considering your contribution or achievement in one or other field. Hence, don't take it as title. Because it is not hereditary, it is not given considering how loyal are you towards state. It's not for that. It's about how much have you achieved or served the society. Hence, don't take it as that. That's the reason Padma Awards is valid. It doesn't violate 18. Got it? So, those are the points. Hence, all those titles have been taken out. Whatever the Raja, Maharaja, all those things. But you might see, sometimes they keep referring to the term called as Raja and Maharaja. Even in the media, they keep using that. But don't get confused. Media will use it. But we are not talking, only talking about what? Government should not give them titles. People, left to them, they can give any titles to anybody. For a lot of like what says these Swamijis, they use the term Shri Ravi Shankar. Those are all Shri. The Government of India is not giving. People give it. So we can't help. Government should not give it. Got it? So that is the logic. So next time when you see those, don't get confused. Clear? That is, state should not give. Then let's say if you are an Indian, then what you should not do? You should not take such titles from other countries. This was actually an issue with respect to Sachin Tendulkar also when he was in, like, because if you have heard, if you follow cricket also, I mean even relatively also you can understand, like for those people who achieve to the top level, the Queen of England or let's say the Crown of England gives a title called as Sir. Sir Don Bradman, Sir Viv Richards, Sir Gary Sobers, like that. They wanted to give the title Sir to Sachin, I mean the Queen at that time, Elizabeth, Queen Elizabeth. But then they said no, because what it is valid? It will be considered as a title given from when? Other country, not allowed. You can take award. Recently you got RRR movie Oscar award. That is considering your merit. But again it is not given by Queen and all those things, hence they allow it. So don't confuse with Oscar award, you can take that. Lot of people, you may be awarded, for example, some other countries, highest civilian honor they may give. I think for Prime Minister Modi himself has got highest civilian honor in so many countries. That's an award. That's not a title. So like that they differentiate. Sometimes it may be a little confusion also. Whenever there is confusion, courts will clarify. But these are all, I think I give you a broader, this is called as title. This is called as award also. Fine. And even this applies for foreigners, that's what you have written clause 3 and clause 4. Let's say, what do you mean by that? Let's say for example, there is a economics professor. He belongs to UK, but he is working where, or he belongs to France, but he is working as a professor in, let's say, some IIT, some IIM, some AIMS, JNU, anywhere, Delhi University, somewhere he is working as a professor. So that means Government of India has appointed you. Now because you are working for Government of India, then what you cannot do? You cannot take any title from anybody. Only exception is what? President should give you permission. Citizens cannot take any time. We are talking about foreigners may take. Only exception is what? Take President's permission. Sir, why are we talking about all these things? Reason, the assumption is that loyalty issues, one is equality issue, that's why it is mentioned under 14 to 18. Treat everybody equally kind of a one. 2, loyalty matters. Means what? If you take titles from other countries, they have assumed that your loyalties may shift towards them. You should always be loyal towards Indian state, Indian government. That is one of the reasons, but core reason is equality, that's why it is under 14 to 18. Remember? Yeah, that's a broad idea about these titles. Yeah, clarify all these points below. Clarify the points. The only exception is what? The only exception to the titles is academic and military title. The only exception to the title is academic and military title. That means doctor, you write those things, you know, army general, major, captain, etc. Only exception to the titles are the academic titles like doctor, military titles like major, captain, etc. Fine, that is 1. 2, again below clarify. Titles like Raja, Nawab, Nizam, etc. are against Article 18, hence unconstitutional. Titles like Raja, Maharaja, you know all those things. Titles like Raja, Nawab, Nizam, etc. are against Article 18, hence unconstitutional. Are against Article 18, unconstitutional. Fine. Then again, next one. Supreme Court has clarified that. Supreme Court has clarified that Padma Award is not a title. Supreme Court has clarified that Padma Award is not a title. Padma Award is not a title as it is given. Padma Award is not a title as it is given based on their merit. As it is given based on their merit and contribution to the society and nation. As it is given based on their merit and contribution to the society and nation. That means it is constitutionally valid. Fine. So last year's 2021 there was a question, if you want just in again clarify. Supreme Court has also said that Supreme Court has also said that Padma Award should not be used as prefix or suffix to the names. Supreme Court has also said that Padma Awards should not be used as prefix, means before your name or after your name, prefix or suffix to the names. That means you can't officially you can't keep using that name. Fine, prefix or suffix to the names. Clear, that is another clarification. The next one, just this was a 2021 question also that has, that's why I clarify. Padma Awards was only discontinued twice. This is not related to 18, I am just clarifying it. Padma Awards was discontinued only twice. Means it started in 1854, it has been discontinued only twice. First by Janata Party because it was against Indra Gandhi and they discontinued. Padma Awards has been discontinued only twice. Fine, because it is after independence. One is what? First is by Janata Party, 1977 to 79 or 80 you can say. First was by Janata Party, 77. Second by P.V. Narasimha Rao government. He discontinued it for 2 years. Fine. That is Article 18. Broadly, we have finished one broader fundamental right, right to equality. Under that, 14, 15, 16, 17, 18, 5. Now providing right to freedom. Right to freedom, Article 19 to 22. Right to freedom. So this is another one very important, Article 19, first one especially. Which title? Yes. Which one? Privy purse was there. Privy purse, they did not give you a title because you were king in the past and then you accepted to join democracy. They had given it. Okay, anyhow you have asked it. There was a concept called as, you can write anyhow we have written about Raja, Maharaja, everything. Have you heard there was a concept called as privy purse? Privy purse means in simple terms, because the princely states or the kings agreed to join India, what did the government of India say? We will give you as a compensation every year so and so amount. Annual royalty, annual pension you can call. It was based on what? It was not equal for all the princely states. It was based on how big was your revenue. Hyderabad got the biggest annual privy purse because Hyderabad was the biggest princely state. Mysore got the second because Mysore was second largest. I think third was Jammu Kashmir. Fourth was what? Travancore, whatever. Basic point, it was not equal for all of them. It was prominent. And Sardar Patel was a person, because he had negotiated all these things with integration, he strongly argued for that in Constituent Assembly also. Because a lot of people, because Nehru was by definition or by concept against monarchy and all those things, he said there is no recognition for, because he was inspired from socialism, communism kind of a one which doesn't recognize this or completely against these monarchies. But Patel was a different, a little bit more ones, so hence he had argued strongly, it continued. Remember, privy purse was mentioned in the constitution itself. Fine. But after 20 years later, 1971, 26th constitutional amendment 1971, Indra Gandhi made it a political issue in 1971 elections and at for election what she did? Abolish through 26th amendment, and Supreme Court has upheld it also. It was undone. One, it was against democratic ideals was the argument. Two, that it is putting huge burden on the, already government was suffering from financial resources, and she argued it is putting huge burden on the government again. That was also undone. Alright, anyhow I have written, in margin you clarify these things. Privy purse. First point is what? Define what do you mean by that. Privy purse. It was an annual royalty or pension paid by. It was an annual royalty or pension Annual royalty or pension paid by the government of India to the paid by union government to the kings or princely states who had agreed to join India, given to the princely states who had agreed to integrate with India, who had joined India, who had agreed to join India. Second point, was it equal? It was not equal for all the states. States means, don't confuse, all the princely states. It was not equal for all the princely states. It was not equal for all the princely states. Then what did it depend on? It was based on that means what? How much revenue they had. It was based on their revenue generation. Means how much they generated before, when they were kings. It was based on their revenue generation. Fine. Hyderabad, Mysore, Travancore got the highest. Before, when you are king, how much money were you making? Yep. Correct, obviously. Before they integrated with India. Hyderabad, Mysore, etc. got the largest share. You don't have to remember numbers, everything, you can't do all those things. Broadly, that is the point. Fine. And where was it? This is the most, it was mentioned in the constitution itself. Exact article I am unable to recall, you go search it. I think 361 or something. It was mentioned in the constitution itself. It was mentioned in the constitution itself. Then write this. This one. Discontinued. In other words, actually abolished from the constitution itself. It's not there in constitution now. Took the provision away. That means abolished it from the constitution. Abolished the provision from the constitution. Fine. And now come back. Let's write what all is there under Article 19 and then we'll take a break. Come back, it's fine. Article 19, it has 6 components. Article 19, it has 6 components. Actually it was 7, but one is abolished again, we'll discuss that later. It has 6 components. Under that first one, Article 19, Clause 1, Subclause A. Article 19.1, Subpoint 1, subpoint A like that. 19, Clause 1, Subclause A. What is it? Freedom of speech and expression. Freedom of speech and expression. Then, just write the list first, we'll discuss each one. 19, Clause 1, Subclause B. Clause 1, Subclause B. Freedom of assembly. Freedom of speech and expression. Freedom of assembly. Then Subclause C. 19, Clause 1, Subclause C. Fine. Freedom of association. Freedom of association. Subclause D. Freedom of movement. Freedom of movement. 19, Clause 1, Subclause D. Freedom of movement. Then Subclause E. Freedom to reside and settle in any part of the territory of India. That will just write freedom to reside and settle. Freedom to reside and settle. And actually it is F, but F is removed. Directly write G. 19 clause 1 subclause G, freedom of profession. That means to earn your livelihood, freedom of profession. Fine. These are 6 within one article, and that too obviously the most important one is your first one. Just put the heading and then we'll do it later. Freedom of speech and expression. Freedom of speech and expression. Take a break. Okay, come back. We'll start with.
Sir, is the reservation based on equality of outcome?
Obviously, I have given, then itself we have mentioned, any kind of affirmative action, positive discrimination is obviously aiming for equality of outcome. Reservation is the most famous, most positive measure for that. Fine. Anywhere, anytime, if there is a question on reservation in your entire UPSC history, you should always back it. Yes. If there is anything, you can identify the criticism. Like for example, you can say, sir, we have to make sure that the benefit should reach the last person. There is a class within class who are getting benefited. Actually, there are a lot of other poor who has to get the, like let's say subcategorization. That one you tell. Don't tell that nicer. I think the idea itself should never ever in UPSC history. Not allowed. Fine, because it is based on the equity concept, it is based on equality of outcome, you should always support it. Fine, identifying the criticism is different, opposing the idea is different. Fine, so please don't take that after fundamental rights if you start opposing it. So, no way. Fine, yeah, please note down, there are so many things under this. Again, we'll have a lot of discussion. 19 clause 1 subclause A, freedom of speech and expression. It is a very broad article. It is a very broad article which includes multiple components. It is a very broad article which includes multiple components. And then just keep writing the list. A very broad article which includes multiple components like A, freedom of press. Freedom of press. In bracket you can write there itself the cases. Ramesh Thapar case, freedom of press. Ramesh Thapar case. Brijbhushan case. Ramesh Thapar and Brijbhushan. Brijbhushan case. I think BHU, Brijbhushan case. Fine, that is freedom of press. Then freedom of creative expression means to make your own movies, paintings, novels, whatever you call them as. Freedom of creative expression. Freedom of creative expression. Yes, Rangarajan case. Of course, the recent one like Prakash Jha related one movie. Remember, you have a Hindi director called as, again there was a movie of him, Prabnath, all those things are your freedom of creative expression. Fine? Yes, Rangarajan case. Yes, Rangarajan case. Then right to know the activities of the government. In simple words, right to information. Right to know the activities of the government, or you can also write it as I said, RTI. Right to know the government activities of the government, or RTI also you can say. In bracket you can write what cases? PUCL case. People's Union for Civil Liberty, right? PUCL in capital. PUCL case. Again, there are many SP Gupta case, many are there, but one of the case I am telling, that's it. Then right to criticize. Right to criticize the government, which includes rights to dissent. Right to criticize the government. Right to criticize the government, which includes right to dissent. Which includes the right to dissent. In bracket, Bhima Koregaon case. BHIMA, Bhima or BIMA also you can write. The Bhima Koregaon is a place in Maharashtra. Bhima Koregaon, KOREGAON, Koregaon case. Bhima Koregaon case, right to dissent. Fine, we'll discuss all those things. Then right to silence or freedom of silence. Freedom of silence In bracket you can write Jehovah Witnesses case. JEHOVAH. We'll discuss all of them. Will one after the other. We'll discuss JEHOVAH. Jehovah Witnesses case. Jehovah Witnesses case. You can also write other name for it because this is famous name, officially called as Bijo Emmanuel versus State of Kerala or Bijo Emmanuel case. BIJOE. Bijo Emmanuel. EMMANEUL. Okay, right. Bijo Emmanuel, but very famously called as Jehovah. Why is it called as Jehovah? All those things we'll discuss. Jehovah Witnesses case. Jehovah Witnesses case. Fine, this is another one. Speech and expression. Fine, then there is sedition is also there. Okay, fine. So this and you can also write against telephone tapping of conversations. Write against telephone tapping. Write against telephone tapping. Rights to internet. Rights to internet. Anuradha Bhashin case. Anuradha Bhashin. This is related to the Jammu Kashmir one. Anuradha Bhashin case. You can also add Fahima Shirin case. Fahima Shirin case. Then freedom to publish one's own as well as others' view. Freedom to publish one's own. That means your own. Freedom to publish one's own as well as others' view. Freedom to publish one's own as well as others' view. As well as others' view. Fine. Then next one. Right to picket and demonstrate. Right to picketing. Right to picket or right to picketing and demonstration. Right to picket and demonstrate. Fine. So like that, these are all broadly the part of your 19 clause 1 subclause A. Fine. So look at the list. How broad is it? Right from what? Right from you can publish your own view. That means you can express yourself. You can write an article, you can write a novel, book, make a video, give a speech, make a movie, make a painting. Right from that creative expression as well as not just yours. You can also publish that of others also. That is one broad. Then of course freedom of press, because obviously it's the most important. That's what we keep calling it as what? Media is called as the fourth pillar of democracy. Media is called as the watchdog of democracy. Because if media is not independent, then how will you check the people in power? So obviously freedom of press is very, very important. Fine, that is more than obvious. Fine. Then for example, right to criticize the government, right to know about what the government is doing, right to information, and right as well as right to dissent. You have written the word. So what is the word? You have also written the word dissent. Where you have written the word dissent, in margin you tell what do you mean by that. Or in general, what do you mean by dissent? Define. Dissent. It refers to, or it means having an opinion. It means having an opinion. What do you mean by dissent? Having an opinion which is contrary, which is opposite. Having an opinion which is contrary to. Having an opinion which is contrary to the popularly held opinion. Having an opinion which is contrary to the popularly held opinion. Which is contrary to the popularly held opinion. Means what? Most of the people think one way, but you may think another way. But that's absolutely fine. That's what you call it as right to dissent. you can have an opinion which is against the popular opinion also. You can also add there itself, see, Justice Chandrachud had described it as, in that case he was judge, of course now he is CJI. Justice Chandrachud had described dissent as safety valve of democracy. Justice Chandrachud had described dissent as safety valve of democracy. Safety valve means, understand, right? He compared that democracy is like a pressure cooker, and then you remember you have that small valve where you have all the pressure may escape. What if you block the valve, what will happen then? It's like that. That means if you don't allow the criticism or different opinions to easily flow in the society, then the democracy will explode. People will start protesting or revolting, rebellion, civil war, anything can happen. That's why dissent is considered as a safety valve of democracy. Fine, a very important one. Clear? Then of course, publishing, creative expression, all those things are more broader ones. Now we have written another one called as freedom of silence. Silence is, in which case we wrote that? Jehovah Witnesses case. Fine, it was a case related to, I'll tell the case, you'll understand what you mean by it. It was a case related to which one? Kerala. Jehovah Witnesses means actually it is a subsect. Subsect means within Christianity they are one group. Like how within Hinduism you have Shaivites, Vaishnavites, Smarta, this, that, like that. So many are there. Within Christianity they are a group. They are not just in India, they are there across the world. Fine, even when Hitler attacked Jews, he also attacked these Jehovah Witnesses. What is the core point of their belief? Let them be across the world, wherever they are across the world. They will not praise any particular, state. They will never, wherever they are across the world, they will not sing any country's national anthem or state anthems, nothing. They will only, because according to them, they should only praise their God. Means you take it as Jesus. Whatever, some specific things may vary, that's a different issue. Fine, that is their core belief. Now then what happened? This is actually the father's name, Bijoy Emmanuel. Bijoy Emmanuel's children were there. That means Jehovah Witnesses. Now obviously we know, even in your schools you might have heard that in your morning prayer what do? You sing the national anthem. So they used to stand there, their children, his children, Bijoy Emmanuel, they used to stand in the queues but they never used to sing the anthem. They just used to stand silent. Whenever forced that, they used to tell, that means we are not supposed to say that because we only praise our God. So then obviously the children were suspended from schools. The case went to Kerala High Court. Kerala High Court said that no, you should sing the national anthem, you are in India, something like that. Case came to Supreme Court. And Supreme Court said it is part of their Article 25, freedom of religion. You cannot force anybody to sing national anthem in a country, in a democratic country. It is their liberty, let them take the call. Fine, if it is going against their core religious belief, it's absolutely not necessary. Sir, is it how is it anti-national means what? If you are trying to do anything, for example, let's say you attack someone, like Amritpal Singh tried to do some whatever, if you are deliberate, it is in your deed. Deed means if you do some action which is trying to hurt the public order or anything, then you face the law. Punishments, everything is the same. But here you are not trying to disturb others. You are not involving in some other terrorist activity or something. You are not writing a speech saying against the Indians. Nothing you are trying to do. Hence, or you are not criticizing other religions that you are trying to sing this. Hence, they said, even if a single individual has a different opinion, you have to respect that and it stays. Now, the children were told that they should be reappointed, readmitted to the schools, and they are readmitted. That is what you call it as freedom of silence. You can just stand, you don't have to necessarily sing. That was the landmark Jehovah Witnesses case. It is part of this, and then religion also came in picture. Freedom of religion. Got it? So I think you got an idea. Jehovah Witnesses, Bijoy Emmanuel case. That was the point about. Then like that, what does it be right there? Right against telephone tapping. If you don't know that, telephone tapping obviously is not allowed by any government officials. In movies they show that all of a sudden the police, all things not allowed. If in case under Telegraph Act of 1885, if any telephone conversation has to be tapped, it has to be done on the permission of the Home Secretary. If you want to do it in a particular state, the Home Secretary will be there at the state level. They should give the permission, not by SI, SP, no, Home Secretary of the state. Exceptional cases may be different. In general, you should take their permission. That is for the telephone conversation under Telegraph Act 1885. Fine. Then you have also written right to internet, and there you have written a case called as Anuradha Bashin case. Can you see that? It was a case related to the Jammu Kashmir one. Remember abrogation of what 370 in 2019, and after that almost around 6 months or 7 months telephone connections, internet connections, everything were shut down. So obviously Anuradha Bashin questioned that in the Supreme Court, saying, is it not violating their freedom of speech and expression? A lot of people have do businesses on internets, like e-commerce, everything. So what about their professions then? What about their livelihood? What about, in simple words, if you want to express yourself? What if the internet connections are completely cut like that? That's why it was, remember there was a word called as internet shutdown. Even few days back, even in Punjab it was shut down, right? It's still there? Okay, fine, yeah. Those are all internet shutdowns. India is called as the internet shutdown capital of the world. Fine, because one small event, best thing, completely shut off internet. Because we know in the social media era, that is a major source of connecting with the people and all those things. All those things we do. So how do they do it? Actually, internet shutdown is done under Telegraph Act of 1885, and they have if you want, you can write that in margin. You write where you have written Anuradha Bashin case. There you can write internet shutdown. And first define what do you mean by that. It refers to temporary shutdown or temporary discontinuation. Internet shutdown, it refers to temporary suspension of. It refers to temporary suspension of telecom and internet services in a particular area. Temporary suspension of telecom. Temporary suspension of the telecom and internet services in particular area. In a particular area. Fine. So how do you do it then? It is done under, it is done based on, it is done under Telegraph Act 1885. It is done under Telegraph Act 1885, and under that act there is a rule. Telegraph Act 1885 and temporary suspension of telecom services rules. So both are very important. Telegraph Act 1885, temporary suspension of telecom services rules 2017. So underline both the words. Temporary suspension of the telecom services rules 2017. Got it? So that is internet shutdown. And now, as of now, it is very strict. Actually, you have to take even if the state government shuts it down, within 24 hours, the Union Home Secretary has to, you can write that one single point. Union Home Secretary is the authority, officer responsible to take decision for this. Union Home Secretary, MHA. Union Home Secretary is the person, is the authority. Union Home Secretary is the authority responsible to take decision under this rule or take decision related to this. Responsible to take the decision related to it. Take the decision related to it. Fine? Like that. These are all various aspects related to freedom of speech and expression, a very, very broad one. Fine? Yeah. So now, have you written anything? You can also write another one. So this you can actually, there are a lot of points related to it. Put the heading called as Dissent. I have told you what do you mean by that. There's another keyword because this is related to freedom of speech and expression we are discussing. What is it? Sedition section 124 capital A IPC. Section 124 capital A IPC. Write few points, you will only understand that. First define what do you mean by that. It means It means any kind of expression, means it can be through words, spoken, written, anything, so many they tell. I'm just using simple words. It refers to any kind of expression which tries to create any kind of expression which tries to create disaffection, any kind of expression which tries to create disaffection or contempt, disrespect, that is, disaffection or contempt towards the legitimately elected government, which tries to create disaffection or contempt towards legitimately elected government, or just tell towards the government, towards legitimately elected government. So actually by definition, if you go, what does that mean? If you are criticizing any government policy or any prime minister or chief minister or an MLA or MP very harshly, that means what are you doing? That means you are asking the people that so and so prime minister is not working well, CM is not working well, so and so minister is, they will take it as sedition then. So any kind of disaffection or contempt, this was the controversial. What do you mean by disaffection then? Anything you criticize they'll hurt. That means what, you should not criticize then. If you don't criticize, then how do you put a checks and balance? How do you call it as democracy then? All these questions came up because remember, this was done by British. British had arrested more or less every major leader under sedition. Anybody who tries to criticize British, right from Bal Gangadhar Tilak, which happened in the beginning of, because he, the first one, who first major leader arrested under that, to Nehru, to Gandhi, to Patel, to more or less everybody have been arrested under sedition provision. That is pre-independence. But post-independence, we are a democracy. How can you allow that kind of provision to stay then? Because if it is there, how do you criticize the government then? It can be easily misused against the opposition and the journalist, media. Hence what they has done. I mean, got it? What do you mean by sedition? Any kind of information, expression which affects the government or disrespects the government is sedition. But of course it can't stay below that mention. A landmark case, so many cases are there, but first let's the landmark case. Kedarnath Singh case. Kedarnath Singh case. Supreme Court narrowed down. Narrowed down means the scope. Earlier sedition means each and everything. Now it is all narrowed. Only this is sedition. Supreme Court has narrowed down the meaning of sedition. Someone, remote. Supreme Court, why? Okay, fine. If it is fine for you, then it's fine. Supreme Court has narrowed down the expression, narrowed down the scope or meaning, narrowed down the scope or meaning of sedition. Then what does it include? At present it only includes, those expressions. At present, it only includes those expressions which tries to incite violence. Incite means, that means you are asking the people to get involved in violence. Any expression which tries to incite violence, trigger violence, or deliberately disturb public order. Any expression which tries to incite violence or deliberately disturb public order. Deliberately disturb public order is called as sedition. That's it. Rest, nothing is sedition then. So you should incite violence or you should try to deliberately disturb public order, then it is sedition. Because remember, under IPC, sedition can be punished up to life imprisonment, to that level it is there, it's a cognizable offence. That all we'll discuss later. Fine, that are the points. Fine, now hence it has narrowed the scope. Now other cases you just add. What is it? The recent one you might have heard. JNU, what is it? Kanhaiya Kumar case. Kanhaiya Kumar case is also related to sedition. Remember which is now where they are famously made as Tukde Tukde gang, Azadi gang, everything they are named. All those things, even if the case was put, what happened to them? You can't put anything because it is considered as broadly part of speech and expression. You may not like their speech, but democracy, as we keep telling, is what? Agree to disagree. You may not like it, fair enough. That doesn't matter. No, sir, my emotion are hurt. Doesn't matter. So that is the point. Fine, Kanhaiya Kumar case, Binayak Sen case, etc. Like that, many are there, ROV case like that. There is also a very famous statement Supreme Court has said, in this context sedition, you can write that. Supreme Court has also clarified that, Supreme Court has all, this was actually again in the, what do you call this, the Khalistan related one. Supreme Court has also clarified that mere sloganeering means what? If someone shouts Khalistan Zindabad, so many slogans are there, right? All those things. Supreme Court has clarified that mere sloganeering does not amount to sedition. You may put a case under them under other aspects, but that's not tradition. Mere sloganeering does not mean or does not amount to sedition. Fine, does not mean sedition. So like that, these are all things. And even recently what Supreme Law Commission has suggested a repeal of this provision. Law Commission of India, which is the highest body with respect to legal reforms. Law Commission has suggested repeal of section 124A. Law Commission has suggested repeal of section 124A. You can also clarify, Supreme Court recently has said, Law Commission suggested to repeal section 124A. Supreme Court has recently said that no new cases should be registered under 124A. You can't register any new case. Supreme Court has recently said, this was just Chandrachud after he became the CJ, or probably Lalit Kumar, I've forgotten exactly. Fine, no new cases should be registered under section 124A, and it has also said the pending cases should not be continued, trial should stop. No new cases should be registered under 124A, and the existing cases should stop, means no trial should continue. Existing cases should stay. Stay in the sense, nothing, no punishments, nothing under that now. Fine, so maybe probably Supreme Court is ready to repeal it. Fine, obviously Chandrachud wants a huge legacy. So section 124 goes, so many things will go now. So another 2-3 years. So we have to see how it happens. So those are all broadly, okay fine, these are all what? Freedom of speech and expression, broadly things. Now below that, reasonable restrictions. Again, as we already told, no fundamental right is absolute. What is it? Qualified. So what is that? Reasonable restrictions. Fine. Again write huge list. First one, sovereignty and integrity of India. First ground. Sovereignty and integrity of India. Sovereignty and integrity of India. B, security of state. Security of state. C, friendly relations with other countries. Third one is friendly relations with other countries. 4, public order. Public order. 5, decency or morality. Decency or morality. Fine. 6. Contempt of court. Contempt. Contempt means I have already told you broadly what does it mean. Disrespect, disobedience, contempt of court. Then whatever next one. Incitement to offence. That means you are instigating the people to go burn a police station, this, that and all those things. Incitement to an offence. And then last one, defamation. Remember yesterday, Rahul Gandhi case, defamation. He's been disqualified. How all those things, you'll get to know. Lily Thomas, very famous case is there. Will it stand now? And it is setting a new precedent, because if you don't know what they have told, all those things in speeches, there is a defamation. Definition is, I mean, in the sense, a generic reference to a surname, you can't use it for a specific reference. Means what they have told is, if you have heard, I mean, he has told some line. Now, if you go by that, there is no end. Everybody is defamed. What will politician refer to another politician very in a dignified manner?
No.
That yes, I respect you. I only have ideological differences with you. I counter you. Do they speak like that? If you go by that, actually there is no end. So they have set a new precedent now. In fact, now they are trying to make Rahul Gandhi more famous now. Anyhow, he had got some kind of at least some advantage through Bharat Jodo. Now you are just giving him another advantage.
He will get more sympathy also.
So those are all we'll see. Whatever history. But the point is that we'll discuss from the legal perspective. What is Lily Thomas case? What is the defamation? All those things we'll discuss under your Parliament chapter. What is Section 8, Subsection 4, RP Act 1951? 2 years or more. If you get a conviction, you'll be automatically disqualified. All those things you need basics for that. Then we'll discuss later. So now you have to add there Rahul Gandhi case also then. Of course,
But in criminal defamation, it need not necessarily be to a particular individual that you are referring to.
That's what, that is they have to tell, but what Kapil Sibba, I mean, and then this some other lawyers, what they are broadly telling now is.
Congress's defense is that it should not
Ah.
be with respect to large.
Exactly.
But the legal position is, if you are referring to one particular person or a community, like the person's having the surname of Modi, the person who's the petitioner in this case, he is also an MLA.
Correct. I've read that. Some Gujarat MLA, I forgot his name. His name is also some Modi. And he has put the case saying, I am hurt, my sentiment is hurt, community is all those things. Yeah, I've read that. I've read all those things. But that's what now they have also given him an opportunity 1 month. Whatever. Today, if you have seen, Lok Sabha Secretariat has given an order saying, because according to the Lily Thomas case interpretation, the moment court gives an order, the moment order is out, 2 years or more, automatically disqualified. This is just a procedural thing. What will happen until the court, means the higher court, either High Court or Supreme Court, stays the conviction, means they should say that no, whatever the judgment is there, the judgment is not correct. Until then, he is disqualified. If in case by that time they conduct if election commission decides to go ahead with general election, by election for that, Rahul Gandhi cannot contest that also, because if you don't know, under RP Act 1951, the number of years of disqualification is 2 plus 6. 2 in the sense, whatever the number of years of sentence that you have got, like for Rahul Gandhi they have put 2 years. 2 plus 6 means what? 8 years if the conviction is continuing, he can't contest election. Means 2024 is gone, 2029 is gone.
Just like Indra Gandhi's case, like she also was.
So like that is the level number of years of disqualification now. 8 years he can't contest, according to the law. We, of course, high courts will state, all those things will happen, that's how it goes. If you don't, then you are making him hero then. Because that is how Indian politics works, if you have seen. So whatever, that's a different issue. Fine, okay, that we'll discuss again in Parliament, don't worry. So now, for this, that's why there is a very famous criticism which says that the Constitution gives fundamental right in one hand and takes it away from another. Means, you give so much of things, then what do you mention? This is limitation, that is limitation, then why are you giving it then? That's why there is a famous criticism that the Constitution gives the fundamental rights on one hand and takes it away from another. That's fine, those are all criticisms part. 19 clause 2 reasonable restriction. Fine. Fine? Yeah, this is more than enough. Now, yeah, there is another case. Yeah, there is another very famous case. Please put it somewhere, write it. Shreya Singhal case. Section 66 capital A, Information Technology Act. Shreya Singhal case. Shreya Singhal case, section 66, IT means here not Information Technology Act. Section 66 capital A, Information Technology Act. Fine. Again, what was that? Because again the provision had said broadly that because it is information technology, if you make use of any kind of technology based device, it can be a mobile, computer, laptop, this, that, anything, and you spread any information which hurts anybody's sentiment or which is offensive, then it will be considered as a non-bailable offence, you can be arrested. So it was a very broad one. Any information spread using any technology device which hurts, or so many technical words they have used, which is offensive and all those things, disaffection like that, will be considered as a criminal offence and you will be punished for that. So like that, during that time what had happened, actually when the case was to happen, Bala Thackeray's death had happened in Bala Thackeray you might have heard, a very famous Shiv Sena founder and all those things. Then during that time all this WhatsApp, Facebook was very famous. In Facebook was just emerging. In Facebook someone had put a whatever articles, this, that, whatever, saying that the entire city was blocked, and she, I think some female and some whatever they had said, that this is unnecessarily causing disturbance to the people. We also respect the leader, but what is the need for doing a strike, this, that, everything they had told. And the police put a case saying you are hurting the sentiments of Marathas. Why are Maharashtrians and Mumbaikars and all those things, and she was arrested.
So she said they are not come because of the respect, they come out of fear.
And that's what, it doesn't matter what exactly they said. The point is that out of fear, or why are you doing all these things, the city is blocked, economy is this, whatever. The exact statement doesn't matter. Point is in that context, and there was another case also which happened. Finally it went to Supreme Court saying, and she put that case, Shreya Singhal, because she was arrested, that female, under which this point. Facebook, it's a computer, technology based device, spread an information which is hurting other sentiment or which is offensive, which is disaffection, whatever. And Supreme Court said, the exact, what they said was the words used in section 66 here, like any information which is offensive or hurts someone or what you call as disaffection, they said these are all what? Vague. What do you mean by vague? There is no clarity. The moment you have no clarity, what will happen then? Misuse. Hence, taken out Shreya Singhal case, a very landmark case again. Right? What do you mean by that? Yeah, please broadly write what do you mean by section 66A Information Technology Act. It said that, first you write this, first define the act, then we'll write the judgment. Section 66A Information Technology Act, tell what do you mean by it. Any information spread through, any information which is spread through computer based device, or you can say technology based device. Any information which is spread through technology based device which is offensive. Again, so many technical words they had used, so I am just broadly mentioning it, which is offensive or hurts other sentiments like that, which is offensive or hurts other sentiments or causes disaffection, which is offensive or hurts other sentiments or causes disaffection Fine, will be considered a criminal offence. Means you will be sentenced, put in jail, will be considered a criminal offence. That was the point. Clear? And what does the Supreme Court say? Supreme Court said that, and write this. And you put your sentences there. Supreme Court said that the words used are vague, vaguely termed. The words used are vague, hence no clarity. The terms used are vague in nature, hence no clarity, which obviously will lead to what? Misinterpretation, misuse. Hence violates 19 clause 1 subclause A, hence under 13 it is declared unconstitutional. These words are vaguely termed, hence there is lack of clarity, hence there is no clarity, which may lead to misuse or which will lead to its misuse. Lack of clarity which leads to its misuse. Fine. Then again clarify. Section 66A violates 19 clause 1 subclause A. That means it violates your freedom of speech and expression. 66A violates 19 clause 1 subclause A. Hence what? Declared unconstitutional. Hence declared unconstitutional. This is actually a UPSC mains question also. That year, whenever the judgment came, I think 2014, 2015 they had asked, I guess. It was declared unconstitutional. Clear? So we have written this word. This will take a lot of time, don't worry. This, if you understand this, other articles is very easy. Where is the word I wrote? Picketing and all those things. Where you have written picketing, there go clap. Picket means what? Let's say you stand outside a company and tell the people not to buy goods from this, that, everything you heard. Those are all called as picketing and demonstration. We have written picketing and demonstration there, right? Supreme Court has clarified that right to strike is not a fundamental right. Strike means what? Remember, band they call it as. Band is not your fundamental right. Supreme Court has clarified that right to strike is not a fundamental right. A right to strike is not a fundamental right. Right to strike is not a fundamental right. Clear? Yeah, these are all broadly the points related to it. Now, freedom of assembly. Clause 1, subclause B. Again, let's write few points. Now there were, recently Supreme Court has given a reinterpretation of freedom of, I will tell you an example. See, let's say for example, now obviously you know, last year what is the movie of Amir Khan, whatever, for everything they should tell ban, so rejected, was boycott campaigns and all those things. Now take two examples. Can the government ban a particular writer's movie or government ban particular directors or heroes movie and allow another particular hero's movie? That's what they can only see under CBFC, they can only certify it. But can the government ban it, boycott completely one boycott? No. Now let's say you are a theatre owner, you are a bookshop owner, you don't like a particular writer. You are owning a bookshop. Fine, you don't like a particular writer. Can you say that this writer's book I will not put in my shop? Yes. You can say that. But let's say your government, your CBFC head, can you say that this hero I don't like, I will not allow his movie? No. That means what? That's the reason we keep telling this one was applicable against state. As a state you can't do it. As an individual you can allow it. Now recently Supreme Court has broadly said there is something called as vertical interpretation, horizontal interpretation, that even vertical interpretation is also allowed. In the sense, not just state, we can also apply it against private individuals, 19 clause 1 subclause A. But what does that mean? How all will be interpreted? We have to wait for that. But basically get an example, keep that in mind. Whenever any major issue happens, we'll come across that. Fine, okay. So leave that, come back to freedom of assembly and write. It provides freedom for the citizens. Remember 19 is only for citizens. It provides the freedom for citizens to assemble peacefully. It provides the freedom for citizens to assemble peacefully in public land, to assemble peacefully in the public land without arms. ARMS, without arms. That is called as freedom of assembly. That means you can assemble, you can protest. I mean, the landmark one you have seen the last 2-3 years, Delhi is obviously the center for all others. Remember, the farmers' protest, 1.5 year almost. So all those things, CAA protest happened, JNU, so many things have happened. Freedom of assembly, freedom of protest, everything is allowed. But look at the words they have used. Where is it allowed? It is allowed in public land. You can't go sit in front of someone's house there or someone's property, not allowed. That's why they sit in Jantar Mantar, Ramlila Maidan, like that. Some designated places will be there. That they allow. Fine. Then without arms means what? You should do it peacefully. Without, you can't carry a weapon and then say, okay, I will sit here. So in public land, obviously not allowed. Without arms, peacefully. Fine. And it includes all kind of events. It's freedom of your. It's part of your protest. Fine. But sir, what if they try to block highways, sir? What if they try to block railways, sir? They are sitting peacefully only, but they are sitting on the railway tracks. What will you do? That's what is the next one. It is subjected, that means just put reasonable restrictions. Because if you have understood speech and expression, these are all will automatically flow. Reasonable restrictions, sovereignty and integrity. First one is sovereignty and integrity of India, and 2, public order. So obviously you will disturb the public orders, they will not allow it. First one is sovereignty and integrity of India, reasonable restriction. Second one is public order. Public order. Fine. So these are the points. So broadly your right to protest, demonstrate, dissent, everything you can include here. That is your freedom of assembly.
Sir, in Delhi there is one permanent zone where the section 144 is always applied.
Where? I don't know.
Lutyens Delhi.
Lutyens Delhi. Okay. Because again, sovereignty, integrity, which means the entire North Block, South Block, Parliament, Presidents, Rashtrapati Bhavan, everything you have there. There if you allow it, same reasons, this same ground. Same ground, obviously. Because just imagine, or else, if you can recall, probably I'm not sure about the historical why it happened. Because recently when you had, remember what is his name? Tikayat. Naresh Tikayat, Rakesh Tikayat, all those things. His father was there, Mahendra Tikayat or someone. So during Rajiv Gandhi time, what they had done was this Bharatiya Kisan Sabha, all those things. They had took all these tractors and everything. They came and sat. Remember, you have those big lawns in India Gate. The India Gate stretched from India Gate to Rashtrapati Bhavan. They had come and sat there. Farmers getting the tractors, whatever. I don't know what all happened during that time. If you come and sit there, and there were some lakhs, 2 lakh or 3 lakh farmers, what do you do then once you come there? What will you lathi charge and throw them out? What if they just spread all across and stampede happens, people die? Or what if they get into the Rashtrapati Bhavan? What will you do? Because they came and sat there, Rajiv Gandhi was forced at that time to agree to all the farmers' demands. Free electricity, take it. Loan waiver, take it. MSP increase, take it. Free water, take it. Because that was the power. That's the reason, if you have heard, his son was saying the same thing, that we will also take the tractors and everything, we'll go sit in that huge lawns of India Gate. So that's probably, I'm giving you what all can happen. That's the reason section 144 will always be imposed there. Because public order. Imagine the impact, North Block, South Block, new parliament building. Fine. So Rashtrapati Bhavan, the head of the state. So huge impact. It's not so easy. And it is needed also. Absolutely it is needed. Yeah, fine. Then next, clause C. We'll finish off. This is again a very small one. Freedom of association. 19 clause 1 subclause C, freedom of association. Again the name itself says, look at it, association means what? Get together, make your own groups. Fine, it includes the freedom to get together. It includes the freedom, social capital broadly we call it as, it includes the freedom to get together and form various groups, associations. It includes the freedom to get together and form various associations or groups, anything you can call it as, like. Sir, what do you mean by that association? Like NGO, you obviously would have heard, civil society, NGO, SHG, self-help group, companies, in general any company, NGOs, SHGs, companies, cooperative societies like the Amul Mother Dairies, cooperative societies, fine, trade unions, student groups, pressure groups, trade unions, student groups, political parties, etc. So, freedom of association is again a very, very broader one. Fine, each and more or less everything is allowed there. Any kind of a group. You can get together, make your own company, startup, political party, NGO, pressure groups, students groups and everything. Now, let's say for example you are working in a company, or let's say you are working in railways. Railways have their own, what you call this, employees association, everything. Now, can they force you to join the group? Or let's say there is a political party. Can any political party force you to join their party? Nobody can force you that if you are your company or even outside anything. That's the next one. Supreme Court has clarified that freedom of association also includes, or 19 clause 1 subclause C also includes. Supreme Court has clarified that freedom of association also includes freedom not to associate with any group. Supreme Court has also clarified that freedom of association also includes freedom not to associate. I think you get the point. Freedom not to associate with any group. If you have doubt, in bracket you clarify. It means nobody can be forced to join a group or a party. It means nobody can be forced to join a group, trade union, anything.
Can universities ban student groups?
Banning is not allowed. You have to allow, but there are conditions. Conditions they'll put. That's your next one. Let's say, for example, very simple thing. You might have heard there is a group. I mean, there is IAS Association, a very famous lobby, obviously. Now, IAS Association is there. Now, let's say you want to get registered. Ultimately, it's a civil society. You have to get registered. Remember, they keep telling in bracket they put R. They have to get registered. Now, can the IAS Association say that this MLA, this MP will be our head? Or can the IAS Association say that we will be associated with BJP, we will be associated with Congress? No, or we will support this ideology, we will support BJP ideology, communism ideology, Congress ideology. No, you can't. That's what we tell. If you form an association, you have only, remember they are clearly telling, that's why look at the word, you only have the freedom to form a group. You don't have the freedom to get it registered. You don't have the freedom to get it recognized. Means, just because you make a group, you cannot keep on continuing with that. What will the government do? Government under various acts will put certain conditions. This is the parameter. Let's say if you want to make a state government employees association group or any government employees group, first point they will tell you should be politically neutral. Means what? Don't associate with any political party. I am not telling in general, I am telling you example, if it is government employees association, you can't associate with any government political parties or their ideologies. Then all the members should only be government employees. Nobody, no politician should be allowed to become part of this. Then they will tell you should not openly criticize the government policies or anything like that. Only if you fulfill that criteria, your party, your group is registered. Or else they will not allow it to be registered. Done. Getting? So these are all what you call it as, you only have the right to form it, you don't have the right to get it what? Recognized or registered, because that is done under various acts and rules under which you will have lot of conditions. You should fulfill that condition. Got it? Yeah, please clarify that. 19 clause 1 subclause C only includes 19 clause 1 subclause C only includes the right to form an association. 19 clause 1 subclause C only includes the right to form an association. The right to form an association. That means what it doesn't include then? It does not include the right to get it registered or recognized. It does not include the right to get it registered or recognized. The right to get it registered or recognized. Because what does it depend on? It depends on the provisions mentioned under. It depends on the provisions mentioned under various acts or rules. It depends on provisions mentioned, conditions mentioned under various acts or rules. Various acts or rules. Fine. Now the same logic you apply. Last year, if you have seen, Popular Front of India was banned under Unlawful Activities Prevention Act. Now, our very simple logic, can Osama bin Laden or can Dawood Ibrahim say that this is also my company, I am also making my company, why are you not allowing? Can a terrorist organization say that? That's your next one, reasonable restrictions. Same, just copy paste what you have written earlier. A, sovereignty and integrity of India. Oh, sorry. Sovereignty and integrity of India. B, public order. And C, morality. C is morality. Sovereignty and integrity of India, public order, morality. If you want recent example, write it. For example, that is recently, Popular Front of India. Recently, Popular Front of India was banned under UAPA Act. Recently, Popular Front of India was banned under, same one earlier it was called as SIMI, Students Islamic Movement of India. That was banned. Then they all regrouped and made it as PFI. Now that is banned. Now obviously it will happen again, they will regroup and make another one. That's allowed. But if in case you are violating any of these parameters, any organization will be banned. Fine. Yeah, so was banned under UAPA Act. For same reason, sovereignty issues, public order issues. Clear? That is clause 1, subclause C. Then you have another 3 that we will discuss tomorrow.